Mr. Walden, I think I'll start with you. You mentioned, as Senator Klobuchar did, as others have, that the last set of elections were the most secure elections ever. You accepted that and have repeated that. It seems to me, based on that, there'd be no reason to have this discussion unless you could create a false narrative, in my view, that somehow states are passing massive legislation that changes the voting structure to people's disadvantage. Now, that's different than individual members of the legislature introducing bills. You said the last set of legislative bills are more bills than usual. Now, actually, I think on the Republican side, 22 bills of those bills are in Arizona, and 22 or so of those bills are in Georgia, which I suspect my back of the envelope calculation would indicate that the 4, 5, or 6 bills in other states is about right. Believe me, politicians believe they are election experts, and there are always bills passed, always bills filed, almost none of which pass. Every article on this topic cites your organization and all of this voter suppressing legislation that, one, all isn't voter suppressing, and two, just simply is not going to become law. It's a great excuse to upend a system that served the country well for a long time. On the Utah bill, for instance, that I cited earlier, HB 12 requires the lieutenant governor, who's the chief election authority, to provide Social Security data of deceased individuals to county clerks so they can begin the process of removing deceased individuals from the voter rolls. Why would that be voter suppression?
Well, thank you, Senator. When we look at legislation across the country, we look to see whether the measure is potentially restricting or suppressive.
All right, just on the question I asked, why would that bill removing dead people from the voter rolls based on Social Security information be voter suppression?
Because there are frequently errors in the lists that are used in Social Security and other.
So your view would be the federal government is not capable of telling the state which Social Security recipients died and no longer get a check, so we should turn the entire election over to a federal structure. I just don't agree.
Senator
with
Blunt,
that.
can we allow the witness to answer the question, please?
No.
No?
The witness did answer the question. Okay. The witness answered the question,
Okay,
Secretary.
we'll clarify
Senator,
we'll clarify it later.
Senator, the witness answered the question by saying the federal government often is in error in giving information to the states. That was the answer to the question. Let's go to the Secretary of State Warner, who's here, and the other two as well. You know, we had 3 different views of this from 2 current secretaries of state and one person, Attorney General the Attorney General of Indiana, who was the Secretary of State until the end of last year. I think to some extent that may show why one size fits all maybe doesn't ever fit anybody very well. Secretary Warner, what would be the challenge? You said you'd have to have a special session in the legislature, you think, if this bill passed, and tell me again why that would be the case.
The expanse of this bill would force states to address these issues, such as the funding to get these new machines. When this decertifies all the machines we have in West Virginia, we have to go back and get new machines. That's quite the process to find that funding, to then put it out for bids, that sort of thing. I want legislative directive. Again, that's what our Constitution says. It's going to be left up to the states, and so I want that direction from the legislature to tell me, so then I can execute that, the provisions to implement this vast, as I called it, monstrosity of a bill. There's just too much in there. The clerks are extremely against the same-day voting, same-day registration aspect of this bill. That just would overwhelm them. And as I said, when you don't have the broadband capability throughout the state, it's an impossibility. And so then our legislature would be up to trying to find a way to address what Congress is passing down to them, but then meeting the reality. That's the problem of so much of the discussion that's going on here today. It's talking points versus reality. And that's why I always turn to my clerks, and my clerks tell me that, and unanimously across the board, they are against this S1 because of the unfunded mandates and the expanse that it would impose upon them in the election administration.
And Attorney General Rakita, you said you thought there'd be immediate legal action by a number of states. What would be the principal legal focus of that action as to why this should not move forward?
Thank you, Senator. Well, of course, the constitutionality of this all is immediately called into question, not just with regard to the framers' clear intent that state legislators and legislatures determine these rules, but also in terms of redistricting, which would be completely usurped by the federal government and particularly unelected judges. The people have the most power in this situation when they can hold directly their representatives accountable for redistricting processes. So that's a huge problem. The private right of action that's in this bill that was not in the Help America Vote Act is also a huge problem. When you have individual citizens, like, for example, a prisoner who decides that his rights were now violated as made up in this bill, can sue the states. Untold amount of litigation will happen. So it's not just the states against the federal government. It's this bill would give rights and private rights of actions to citizens for their apparent, not real, grievances, and that will drive up costs to states significantly.
Thank you, Attorney General Rakita. Mr. Goodman, this may be the easiest time to get into your view of this. Do you want to respond to what you just talked about and maybe how the Maryland case you think would apply here that you say already has been determined to be unconstitutional? But respond any way you want for maybe a minute and a half, and then I'll interrupt you if I need to. Is your mic on, sir?
I'm responding to Mr. Wertheimer's comment that the honest ads provisions would affect campaign-related communications. Actually, the honest ads provisions require compel public doxing and disclosure of anyone who wants to speak about any national issue, any public policy issue at all without regard to elections, without ever referencing a candidate for public office. You now have to disclose everything about you and your communications under this bill. Mr. Potter said that there was a trigger of $10,000. That's not the trigger for disclosing who you are when you want to talk online. The trigger there is $500. So anytime someone wants to talk about taxes, abortion, climate change, gun rights, whatever the issue is, and they spend as little as $500 to talk about that issue on the internet in a paid ad, they have to disclose everything about their communication, who they are, and open up their archive. Go into an archive. And one comment about the archive. This bill states what its purpose is. It says that we need to identify for counter speakers and fact checkers who said what on the internet. I do not believe that the First Amendment will tolerate a governmental interest that says you must disclose who you are to empower your political opponents to fact check you and to know what you are saying. So these are fundamental flaws in that.
Thank you, Mr. Goodman. There'll probably be other questions by other members on this. Let's go to Mr. Smith. In the 1974, about the time Mr. Wertheimer was getting involved in all this, the 74 amendments to the Federal Elections Campaign Act took a lot of the enforcement, if not all the enforcement, away from the Justice Department that they thought could easily represent only one side, and transferred that to this newly created FEC that would be required to be represented by both sides. Can you give some examples of, in your experience there, what would have happened if any three of the members would have been able to do whatever they wanted to do? I know the law specifically says there'd be 5 members, and anytime a majority of them are there, that's a quorum. So that would be 3, and our majority of them are currently serving. I'm not trying to get into who's absence or hiding from somebody, but what do you see as some of the real potential problems here?
Well, I mean, that's a difficult question. You have to ask about specific enforcement actions. But basically you're talking about having a partisan majority. And one of the things we know is that not only are there partisan polls, in Washington, and you tend, all of us, we're human. We tend to see things through our prisms, right? But it's not merely that people might say, well, I'm going to get this person because he's a Republican and I've got 3 Democratic votes, right? It's also the natural tendency, like most campaign finance laws affect different groups differently. Different groups have different ways of communicating. Republicans do a lot more work with direct mail. Democrats do a lot more work with groups like Act Blue. If you get a partisan committee, it's easy for a group to say, well, what Act Blue is doing seems perfectly reasonable, but that direct mail stuff the Republicans are doing seems like a terrible violation of the law. In other words, you lose that perspective and you have the ability to force things through. So I think it is a major problem. And if I can say real briefly, I try and answer your question there, but I do hope somebody will give me a chance to talk a little bit more about the PASO standard, because I think Mr. Wertheimer left something very important out of his description of the Supreme Court. Thank you.
All right. Well, others of my colleagues are listening on that. Let me ask one more quick question. I think I can phrase it in a way that's yes or no for everybody. On this issue of independents who can clearly, from all their other activities, function as if they were always going to join one side or the other. On March the 12th of this year, Axios published a memo that had been written by, according to the article, quote, a prominent voice in campaign finance reform world, end quote, and shared with White House staff. This memo advocated for finding ways around congressional intent by replacing a current Republican FEC commissioner with a democratically aligned nominee who would probably be an independent but democratically aligned. Yes or no to all 5 of you? Were you or any organization that you represent or work for, to the best of your knowledge, involved in writing this memo? Not suggesting there's anything wrong with that, but if there is, I may want to ask more questions. Mr. Potter?
No.
Mr. Wertheimer?
No.
Mr. Goodman?
No.
And our other 2 witnesses, Mr. Smith?
No.
Ms. Mueller?
No.
No.
Well, I thought the 5 of you were pretty far into the well-known people who talk about public financing and campaign finance reform and other things. So thank you for those answers. I have a number of letters, statements, press reports, and other documents opposing or raising concerns about this bill that I'll be entering into the record. These letters and statements are from a broad spectrum of organizations that oppose S1, ranging from the March for Life to the ACLU, and covering a broad spectrum of interest from disability rights to free speech. I'd like to enter those in the record if there's
Without objection, so entered.
no objection. Just a couple of questions I have as we finish up, and again, thanks to our witnesses for being here today. Mr. Wertheimer, when I was leaving the House, I guess 2008 was the start of my last term in the House, you were helping set up that Office of Congressional Ethics. That was designed to have membership that were almost certain to be of equal number. Do you think now that was a mistake?
No, the ethics committees have always had equal number
Right.
in this body. But I don't believe that translates to an argument for keeping the Federal Election Commission the way it is.
But you wouldn't expect that Congress to change the Ethics Committee in the Senate to where it had not an equal number. Is that what you're saying?
No. I think the ethics committees in the Congress have always had equal numbers, and we support that.
Well, I would think at the time in 1974, that was at least one of the models looked at, and I've heard what we said about that. I wonder, Mr. Potter, if the commission suffered, in your view, from having a long period of time, most of the previous 10 years until this committee worked to get 6 commissioners in place again. It was a long period of time when either there were 3 commissioners or there was almost never 6 commissioners. This is looking backward at a time when you weren't on the commission. Do you think that was harmful to the commission?
There was a period of, there have been 2 periods of time, to my knowledge, when it has not had a quorum. And I think that is incredibly harmful to the commission. One was in 2008 and one was much more recently, last year, I believe. So yes, I do.
And I think that one had lasted for a while, and then we got a quorum, and then somebody left, and there was no quorum again. We finally do have 6 commissioners, which was in the last decade not the usual practice, and I am glad and was glad to see that. Mr. Smith, in the last round of questions I had, you said if you had time, you had a couple of thoughts about the PASO standard. I believe that. Do you want to address that?
Yes, thank you, Senator. It was suggested that the PASO standard had been upheld by the Supreme Court, and it needs to be noted that the Supreme Court upheld that only in the context of political party speakers saying, and I quote, because actions taken by political parties are presumed to be in connection with political campaigns. So generally speaking, you can't apply that standard to everybody else. It's like saying because Ford once won the 24 Hours of Le Mans, I can take my Ford Flex out and go win at Le Mans next year. And that's just not necessarily true. 2 other things. Much has been said about dark money. It needs to be remembered. Dark money constitutes about 2 to 4% of total spending in U.S. elections, and it has been consistent in that range ever since the Citizens United decision. When we think about it as 2 to 4%, knowing that much of that comes from groups that are very well known publicly, like the NRA, the NAACP, the National Association of Realtors, the nature of the problem tends to shrink a little bit. Finally, Mr. Potter, if I may have misheard him, because I can't believe he would make this mistake, but I thought I heard him say that newspapers had a political ad file that they had to keep. And of course, that is not true. And indeed, the type of political ad file that's promoted in this bill was recently held unconstitutional by the Fourth Circuit in Washington Post v. McManus just about 18 months ago in 2019. And I thought those were 3 points where people should not be left with an incorrect impression about what the reality is and the full story. Thank you.
Thank you, Ms. Smith. Ms. Potter, did you want to, did you misspeak, or is there a disagreement here?
I'm not entirely sure I heard Mr. Smith correctly, but my point was that current law requires disclaimers on paid advertising in newspapers, radio, TV. Radio, TV are required to keep public files of those. Any one of us can go and look at a newspaper and see who paid for it. None of that is true for paid advertising on the internet. It disappears, and it isn't widely available. There is no way, once it has occurred, to go back and see what was advertised or who was paying for it, and that's what this would address.
Mr. Smith?
Thank you again, Senator. I'll just say, again, that type of broad, sweeping public ad file outside the context of public broadcasters recently held unconstitutional in Washington Post v. McManus, Fourth Circuit, 2019.
Thank you. Thank you, Chairwoman.